Hi everyone, my name is Iskuhi Kalantarian, and today me and my group are going to review Chapter 24, Procedural Fairness and Control Effectiveness. Procedural fairness begins with the assumption of innocence for criminal suspects before their conviction. First, their human rights must be respected. Second, the evidence against them must be properly collected, stored, examined, and presented to the court. On the other hand, they want the criminal to be properly punished for whatever they have done. General interests of the society must be protected and promoted. In order to apprehend a criminal suspect in timely fashion, law enforcement agencies may sometimes take some extra legal actions. Among societies in Asia and the Pacific, differences in the organization of law, in regulations of social control, and in human rights standards are enormous. For some examples are the contrasting legal framework. It's common law versus civil law, opposing court traditions, inquisitional law versus civil law. China and many developing societies argue that the most important human rights are survival rights, which need to be affordable basic needs. China and United States seem to practice dimensionally opposing philosophies of criminal justice. United States would rather set free hundreds of thousands of murderers than kill one innocent person. China, on the other hand, is exactly the opposite. They would rather kill hundreds of innocent people than set free one criminal. In large populations, people simply cannot understand why to spend public funds to defend and feed a criminal convict for years before his or her execution.
My name is Melissa Stoudemire, and this is Textbook 2, Chapter 24, The Past. Magna Carta Libertatum, also known as the Great Charters of Freedom, is an English document signed at the end of a struggle between the king and his barons in 1215. This is the earliest sign of the idea of due process. The Magna Carta served as a protection of rights for the king's barons and promised they would not be falsely imprisoned without due process. It is considered to be one of the most important legal documents in the history of democracy. The United States framed the Constitution after elements of the Magna Carta. The Fifth Amendment, for example, states that no person shall be deprived of due process of law. Due process has two components, which are procedural and substantive. Procedurally, due process places restrictions on legal procedures in a way that is fundamentally fair to each individual citizen. Substantively, due process places limits on what laws may attempt to do or prohibit. It prohibits the law from infringing upon its citizens' fundamental rights unless the infringement serves a compelling interest. Therefore, substantive due process is widely considered to be too ambiguous. The due process model of the criminal justice system emerges in the 1960s with court proceedings and interpretations. Chief Justice Earl Warren incorporated the Bill of Rights relating to criminal violations into due process of the 14th Amendment. This gave criminal defendants a constitutional safeguard. With popular cases such as Miranda versus Arizona, the due process model considers the possibility of error in the stages leading to trial. It implements the protective procedures and the rights of the accused. Kirby versus Illinois disregarded the right to legal counsel so much so that it is only constitutionally necessary for defendants who have been indicted or charged with a serious crime. Due process requires that all foreign nations provide foreign nationals a basic level of justice and fairness in civil and criminal proceedings. Control and due process are one and the same when dealing with international migrants.
Hello, I'm from Victor Shaw's Sociology 355 class on Thursdays, and today I'll be going over crime and social control in Asia and the Pacific, Chapter 24, Procedural Fairness and Control Effectiveness, and I'll be starting from the present, page 299, up to effectiveness of control, the bottom of page 301. So I'll start off with procedural fairness has some differences with control effectiveness, which is aka for due processing. Control enforced with procedural safeguards can be more legitimate, acceptance, and influence, while due process procedures can only fare better under widely convincing and long lasting control of peace and order. In Asia and the Pacific, there are more consistent problems and challenges that are unfair for social control to be effective. Some factors for fairness in the justice procedurals would be bureaucratizing states, a well trained profession, and cultural civil society, and well as general social openness and economic accommodations and political tolerance. So I wrote down four ways in which the present justice system can be equal for all. So the first will be procedures may be kept in place, but are from time to time twisted or bypassed wherever the power, the rich, and the knowledgeable get their way to promote some agendas while disregarding other causes. The second step would be well trained legal professional lawmakers, law enforcers, and attorney, prosecutor, judges, correctional officers, and other justice administration or staff with standard education. So I would say up to high school, college level. The third step would be a cultural civil society built upon an educated, disciplined, and tempered citizenry who understand the balances between activism and public order. The final step is an emphasis on procedure and procedural integrity for economic accommodations and sufficiency political tolerance. So meaning that the judges will have some say into what you can go on, what can go on. In the end, across Asia and the Pacific, there is no lack of polarities. Most of the advanced and supposedly freest countries in the region, from Australia, Canada, and Japan to the United States, it is common observation that national security, budget constraints, the war against terrorism, and other continuities take priority, thus shortchanging fundamental principles of justice that a state holds in its constitutional obligation to the people. And that's my portion.
Hello everyone, my name is Agnesia Ranyan and I am going to talk about, um, this is the chapter 24, um, textbook second, and I'm going to talk about procedural fairness and control effectiveness. First, to start off, I would like to mention um, uh, an impoverished man doesn't have much time to ponder what means is most appropriate to obtain food, shelter, and a job in his day-to-day survival. A closed society that always has something to hide from its ordinary citizens or tends to pit one of its population group against another through surveillance and clandestine policy is not likely to put its civil or criminal proceedings on stage for public viewing, nor would it place its government on equal footing with the accused over how the latter can be fairly treated by the former. Even among the most advanced and supposedly freest countries in the region, from Australia, Canada, and Japan to the United States, it is still a common observation that national security, budgetary constraints, the war against terrorism, and other contingencies take priority, thus shortchanging fundamental principles of justice that has a state hold, holds in its constitutional obligation to the people. Crime and social control in Asia and Pacific. An organized justice system is key to running control operations with effectiveness and efficiency. First, there is a rational division of labor among lawmaking, law enforcement, adjudication, and administration of justice. Each organizational branch specializes in its own sphere of work while cooperating with all other branches in the system. Second, individual members perform their job duties in accordance with institutional rules and conventions. Third, there is a reasonable distribution of resources, rewards, and opportunities among sectors, departments, membership groups, rank, and levels of productivity. Procedural fairness and control effectiveness. Um, it's a synchronized public domain, which is essential to ironing out differences and securing consensus over control targets, strategies, and goals. The public domain will, to a large degree, be synchronized across different walks of life while thriving in its apparently diverse dynamism. The solution to the following statement is up to the political cooperativeness which involves the courage, the willingness, and the actual capability of diverse political elements and forces to put aside differences, expand common group, and concentrate on essential goals and substantive tasks that bring about or facilitate unity, stability, and prosperity for all in a country. Thank you.
Hi, I'm Marisol, and my part is the future. Given the fact that neither procedural fairness alone nor control effectiveness per se is close at hand, it would naturally be long into the future for control effectiveness to be achieved under the due process principle, or for the procedural fairness to be maintained with the optimal control and orderliness. At the outset, in combination with attainment of control effectiveness and procedural fairness, requires the presence of coexistence of all the conditions individually necessary for each of them. In other words, only when a state is in place with a united country and well-trained legal profession in existence with an organized justice system, and synchronized fashion is existence with an organized justice system. Only when political forces are cooperative while exercising tolerance, the economy stays responsive while providing various accommodations, and the entire society remains cohesive while exhibiting openness. Can procedural fairness be kept and cherished under the general condition of control, order, peace, and systematically hanged or subjected to harsh punishment? Some American activists are disturbed or infatuated by which they consider as unusual punishments to order countries that they organize public demonstrations to protest or their elected officials to intervene. Similar people in many Asian countries have difficulty understanding why serial killers, heinous murders, are acquitted, why judges dismiss some serial cases while sentencing rather than minor offenders to long-term impersonation, and why convicted killers on death row are seemingly given unlimited appeals for over 20 years in the United States. They assume that the serious offenders should be put to death or kept behind bars as soon as possible without question. And to encourage Chinese, it's simply ridiculous to dismiss a case off the basis of procedural inappropriateness. As some Chinese students argued at legal seminars, the author presents evidence is evidence. It may be collected or incorrected, but evidence gathered with purely technical faults can seamlessly be entered to a valid court as long as it contains relevant unfactured facts.